All right, good evening, everyone. So we got a bit to cover tonight. We're doing two chapters. First up is chapter 11, the Deceptive Trade Practice Act and the Consumer Protection Act, so the DTPA. We've gone over it previously in the past, but this one we're actually going to go super into detail on the DTPA. Our outline, we're going to go over applicability to real estate broker and salesperson exemption form from the DTPA. We're going to go over fraud versus misrepresentation, the Deceptive Trade Practice and Consumer Protection Acts, damages, defenses, and any ethical and legal concerns. So applicability. Real estate broker and salesperson exemption from the DTPA. So the DTPA was originally, we were exempt from it in 1973 when it came out. Real property and real estate agents were exempt from it. But then in 1975, an act amended it that included real property, which directly applied to real estate professionals, causing a ton of consumer lawsuits. So at first we were originally exempt from it, but then they brought us back in, and because of that, we got a ton of lawsuits. People were doing deceptive practices.
Because they were out.
Because we were exempt.
Yeah.
So they had to bring it back and make us not exempt, which of course, like I said, caused a ton of lawsuits. But yeah, originally because we were exempt, a lot of people were doing some deceptive practices, and eventually they had to repute that. It's like if I were to know something about termites in the property, but I didn't disclose it, that kind of thing. It's like, oh yeah, this property's great. There's no problem with it. The holes on the wall, it's nothing. It doesn't have termites. It doesn't have termites. But I know it actually does have termites, and the structure is probably not great. So it got amended again in 2011 with exemptions for licensees. So there's certain things that we're actually exempt from, and that it doesn't apply to us too. So express misrepresentation of material fact that cannot be categorized or characterized as advice, judgment, or opinion. So it's an express statement that you know is false. Or a deliberate non-disclosure. That's if I know it has foundation issues and major cracking and I don't disclose it to them. I don't disclose it to my client. That's a deliberate non-disclosure just to try and get the sale done. An unconscionable act that cannot be characterized as advice, judgment, or opinion. An unconscionable act, what do you think that is, Wyatt? Unconscionable what? What is that?
Like drugs or alcohol or...
Yeah, you're in the right direction.
I mean, unconscious, I know it's like you're out cold.
Well, yeah. So it's unconscionable, like it's... What does a conscience do?
Oh, kind of like the guilt trip thing.
Mm-hmm.
So what, they're like forced into it?
Well, sort of. Unconscionable is just something that would shock the court. It would shock anybody that heard it. If they were to hear it, they would be like, oh my goodness, what were you thinking? Why would you do something like that? That's what unconscionable means. So yeah, if you do something that's so outlandish that even the court guy's like, what in the world is going on here? That would be an unconscionable act. So there are a few exemptions for us as far as the DTPA goes. But view these exemptions with caution, because future case law will determine interpretation of exemptions. So if law changes, it might determine the way that we actually are exempt again. It changed, as here you can see, it changed in 2011, which really wasn't that long ago. They like to change laws all the time. So if something does change, then so might our exemptions. And also ethical standards for even innocent misrepresentations are still enforceable by Trek and Trailer. Trek rules. Yeah, go ahead.
So I wanted to look up unconscionability because I just know Justin mentioned it before, and we all kind of say something, and then we're all just kind of like, I think that's what it means. Like we're all like not really sure. So I looked at the actual definition of it, and it basically means a doctrine in contract law that describes terms that are so extremely unjust or overwhelmingly one-sided in favor of the party who has the superior bargaining power that they
Hey, close that door.
contrary to a good conscience. So basically saying that it's something, if somebody's trying to force something or say something that is so one-sided in favor of them that it's against the good conscience of both parties, that would be unconscionable. I know like one situation I was just thinking of was with Aiden. I know he said he had an agent call him after they sent in the contract and said, how about you don't pay the option fee, but you don't actually get an option period, and then also you don't have a right to terminate at any part in the contract, and we'll just remove that altogether. And Aiden was like, how about we don't? Because that's a dumb idea for us to just be locked in the moment we sign. Like there's a point to that or whatever. Like that is an unconscionable act. Like that's something that like is so unjust. Yeah, it's so crazy and unjust and so one-sided that it doesn't make sense to a person with a good conscience, basically.
Yeah.
Yeah. So like what you're saying, I just wanted to
shock the court.
Yeah, I just wanted to kind
That's
of
good.
clarify
Yeah.
that. Yeah.
Thank you. So even an innocent misrepresentation, if you did it and if you misrepresented and you didn't actually mean to, TREC can still actually enforce rules and regulations on that or disciplinary action. So you never want to take your client at their word. So if you don't know about something, try and find out for sure, because your clients may not always be up for or upright with you. So an innocent misrepresentation would be like if I didn't mean to assume that the foundation was fine, but I told my friend, yeah, it's fine, the foundation's fine, but I didn't know for sure. That would be what an innocent representation would be, an example of one. So they can still, seek action against that. There's a figure in your book, and we're going to go over fraud here. So fraud is a big one, and that one is actually a criminal act as well as a DTPA violation. So there's intentional false representation, reliance on false info by taking a person's act or by a person taking action. So reliance on info that was false. Was there a damage as a result of the reliance on the false information? And it's hard to prove. It's very difficult to prove fraud unless you have it in writing, right? So always remember, like I've been telling you, always put it in writing. If they won't put it in writing, and I keep telling them, hey, can you put that in writing? Can you put this in writing? And they keep refusing to put it in writing, then that should be a red flag to you that they're up to something, because they won't sign something. It's a red flag when someone does something like that. So it's not frequently pursued in real estate transactions. So fraud is not frequently pursued in real estate transactions. A lot of people will threaten it, but not follow through. At least that's what Justin's told me in his experience, that he's had a lot of times that someone will threaten suing for fraud, but they just never follow through with it. So it's not frequently pursued in real estate transactions. And so a criminal act, of course, would be a state matter, but a DTPA violation would be a civil matter. So DTPA is a civil matter. Misrepresentation. So any negligent or innocent false representation, any material factor in the decision to contract, and you do not have to prove intention, and it's easier to prove in court. So misrepresentation is a lot easier to prove that someone did it to them. So you'll see that a lot. You'll see a lot more of that type of suing going on in real estate, misrepresentation. So negligent and innocent. Negligent would be like, what do you think negligent is, Colin? What do you think negligent means?
Neglect.
Just neglecting it?
Yeah.
Okay. Yeah, it'd be like if I were to be texting and driving and getting a wreck. I was negligently doing something and it caused a wreck.
Yeah. So it's not like trying to falsely represent something, but
Yeah,
you didn't take the time to figure it out in the first place.
it's like if someone told me some information about a property, but I didn't actually relay it to my client. I just forgot about it. So out of negligence, I misrepresented them. And innocent false representation as well. So even if you didn't know about it, you can still get pursued. Yeah, so that's what I'm saying. Yeah, don't ever take your client at their word.
Yeah.
You don't know.
Yeah, if they tell you they don't have termites, and you just go, all right, you just say they don't have termites. That's you not taking the time to actually find out if that's true or not. So you're just you're being negligent if you're not caring or trying.
Even if you get them to put that in writing,
Yeah.
we're going to talk about it later, but they can still dispute it.
Yeah.
Yes, sir.
So if that ever happens, you still need to prove it, right?
You would still need to prove that they did it negligently or innocently. Yes.
Also
need to prove it. Yeah, so it's much easier to prove in court, like I was saying. So a lot more misrepresentation or lawsuits come up as compared to fraud, which, like I said, not frequently pursued because it's much more difficult to prove. So, yeah, negligent and innocent. If you're not certain about something, never say it. If I'm not certain that this foundation has an issue, then I'm not going to say it. And if they keep pushing me to say it, then they're probably trying to get a suit on me. So if they're saying, well, what do you think about the foundation? Oh, well, I'm not sure. I'm not a inspector. I think it looks all right, but I don't know. Well, what do you think about the crack over here? And it just keeps pushing me towards it, trying to get me to say, I think it has foundation issues, or this has foundation issues. And he's probably trying to sue me.
You can be as like I think I said that before. You can be vague and like say,
Oh, yeah.
he's like, what about that crack? You're like, well, that could be this or that could be that. I'm not 100% sure, but that is something to look out for. Like that doesn't show it. Yeah, it's like, man, that is a crack. You're correct. Like it doesn't. It's like, okay, you're not saying like that is definitely that. Like as long as you're not like affirming anything,
Yeah, as long as you're not saying for sure, like, that's foundation issue right there. That's foundation issue.
Yeah.
Okay,
Yes, sir.
so you have to be indirect then.
Sort of indirect. You still want to say, well, that could be something.
Yeah.
Yeah.
I don't know for sure. We would need to get an inspector out here if you wanted to put an offer in. And we can get an inspector out and see what actually is wrong with it. But yeah, if you're not sure about something, don't ever say anything about it. And if they try to push you to it, they'll probably try to sue you. Because when you say something and then you said this, and they get there, they sue you for it. So yeah, it's much easier. If you don't know anything, don't say it. Because you could turn to easily negligent misrepresentation. So the DTPA is a state law, and it's intended to be liberally construed, which means broadly construed, and applied to promote its underlying purposes, which is to protect the consumers. It's not to protect the agents or the companies, it's to protect the consumers. And DTPA is actually used in pretty much all market, like if you're buying and selling, stuff like that. All different companies can be sued under DTPA. Big corporations, even if I were to just go out and sell you a cell phone for $100 that I know is broken, you can still actually sue me for DTP for that. even something that small. So it's broadly applied to all kinds of different situations. Yeah, no, so if I sell you so let's say I'm selling you a car, right? And I know this car is broken, but I tell you, oh yeah, it's fine. I can't believe I'm selling it this low at 15,000. Yeah, just buy it. And you end up buying it, and then 2 days later it breaks down, and I'm in another state. You can't find me. But if I had just been upfront and said I'm selling this car as is, if you still agree to buy it, I don't know if it's going to break down halfway down the road, but I'm selling it as is. And if they still agree to buy it, then I'm covered.
Yeah.
So if I had just said something like that,
You gotta change the wording.
yeah. So yeah. And he would probably try and hunt me down. He'd get a private investigator,
yeah.
hunt me
Of
down,
course.
and then I'm getting sued for $45,000
Yeah.
because I tried to make 15 on a broken car. So like I said, it's broadly construed. It can be applied to a bunch of different things. It doesn't matter if it's company or not, company related or not. I mean, yeah, as I said, it's for protection to the consumers. And any false, misleading, or deceptive trade practice any unconscionable actions, like I said, something that would shock the court, and any breaches in warranty. So Wyatt, out of these three here, which one do you think would be the most that they could bring down on you? What would be the most severely punished?
I want to say like the false and misleading one, but I'm feeling the breaches of warranty. I'm not talking.
You're gonna do warranty?
Yeah.
Warranty is actually the third.
Wait,
I said the middle. I said the middle.
Is it the false?
Yeah, you said the middle?
Yeah.
It's the middle.
Oh, okay.
Because remember, unconscionable, it shocks them. You did something
Oh yeah.
crazy.
Yeah. I don't know. I felt like the warranty was like, man. I feel like warranty. You messed that up.
No, I see this one would be number 2.
Yeah, because
So
the first one was in
This one, they would seriously bring down all that they could on you. And this one, they would as well, but breaches in warranty, you would still face charges, but it would be not as bad as almost 30. So almost got it right.
Yeah. Third out of.
It's okay, it's Friday. It's Friday.
Yeah. That's what we do.
I wish you could say it's Friday.
It is Friday.
It is Friday.
I know it is, but I don't feel like it's Friday.
Like you can say that.
Yeah. It's not
Been there
illegal.
before.
No.
So the DTPA, it's a powerful weapon for consumers. Y'all are probably gonna get sick of me saying DTPA tonight, but that's what we're covering.
That is what.
So it's a powerful weapon for consumers because it's easier to prove. Like I said, it's much easier to prove someone deceived you. And you may recover more than your actual losses because we told y'all before, you get to sue for ×3 damages under the deceptive trade practices. So, yeah, like I said, I sold you that car for 15,000. It turns into 45,000. I got to pay. And I guarantee you, if you do that to me, I'm probably never going to do it again. I'm probably never going to deceive someone like that again. And that was the whole point of the DTPA, to persuade people to not ever do it. Because if you do, you're going to be in some trouble. Yeah, so it's ×3 damages, and it does not require proof of intent to deceive, except for a licensee. So you don't even necessarily have to prove that they had intent to deceive. If it's just like if I was selling you a car or something. But licensees, you would have to prove that there was an intent in there. All right, so here's a few key terms. They're in your book. Do you need to know these terms for the test, for the licensing exam? Not really. But if
So
you,
close.
yeah, not really. You don't really need to know these. A lot of these you probably already know. What are goods, right?
Services.
Yeah, well, Services is here. Goods.
Oh, I thought you said to listen to
No, no, no.
What are goods?
Yeah, so we know what goods are, right? This is good, right? I pay for that, pay for that. It's good. Services, we know what services are. We know what a person is, right? Right?
No.
You know what a person is, Wyatt?
I know what a person is.
Okay.
I encountered a few.
What about consumer?
Consumer? Yes, I know consumers.
Okay. Unconscionable?
I've never done anything like that.
You've never done anything unconscionable?
Never. Nothing
Yeah,
shocking.
well, that's good. That's good. That's a good point.
Way to go.
Knowingly and intentionally, we know those as well. I knowingly did something, or I intentionally did something. So that's just a few key terms. They're in your book as well.
Said we didn't need to know and then goes over them.
Yep. I did that. Deceptive acts. So innocent misrepresentation, any misleading statements, and there's something called the laundry list. That's basically if you want to read something that's going to put you to sleep before you go to bed. It's basically just a list of everything that DTPA applies to. So if you wanted to read that, and I don't remember how many pages it is, but I think it's in the millions.
Oh, yeah, it's ridiculous.
It's a lot. But yeah, that's there if you want to look up the laundry list under DTPA. Any corresponding violations of TRAILA, which can result in the suspension or revocation of license. So these are just a few deceptive acts that you can do as a real estate agent. So verbal and nonverbal, there was a court case there. It's in your book as well. It's basically just careful not to recommend experts. You can recommend experts, but I'm not going to just recommend one expert because it's restricting my client to that one person. You can actually get in trouble even for just recommending one of them. When someone asks for a list, or they ask for some professional experts in the field that you know, you can give them a list of them and say, hey, I like this guy, but I have these here. These are all good people in town for you. Pick anyone you want. You can't push them towards one lender or one appraiser and stuff like that.
Okay, so you can't be specific on the recommendations.
Correct.
Like,
So
we have people we use a lot.
Yeah.
For example, but like if you were to ask me for an inspector, I can't be like, oh yeah, call Ryan. I know Ryan, he's a good guy, he'll do it.
Yeah.
Because if I just give you that guy's name and you call Ryan and he comes and does your inspection and messes something up, it comes back on me
Exactly.
for refer, like, because he was the one I pushed on you. Whereas if I go, you can call Ryan or this person, this person, or this person, or this, and I give you like 4 or 5, and you just pick one and call them. If they mess it up, well, it's not my fault. I just threw out some names. Like it doesn't come back as like I forced you to take one guy who didn't mess everything up. So it kind of saves your butt.
Exactly.
Yeah.
Even if you know someone, like let's say if you know someone very well, like a friend or family members, right?
Even then, yeah. I wouldn't recommend it even then. I would give them a list regardless. Say, hey,
Just no one.
these are some people that I know. I've worked with a few of them. Pick whichever one you want.
Yeah.
Because like you said, it could come back on me if I just give them an order. But even if you're talking to your family member, you know, you would like to think they wouldn't say anything to get you in trouble, but even then, I'd still probably just give them a watch. Let them choose.
Yeah.
Let them decide what they want to do. So there was a court case over that, and if y'all want to read up on that, it is in your book as well. All right, so waiver of rights. So this is if you were going to try and waive your rights to basically waive your DTPA. And there's strict guidelines for that. Like if I actually wanted to write a waiver of the DTPA, I waive all my rights there. It's written, it has to be bold-faced, it has to be represented by an attorney, no desperate bargaining position, and even if you were to do something and you have a waiver of DTPA, the judge can actually just say, well, sorry, you did this. I know you waived your rights. He can actually throw that waiver in the trash. So it really doesn't mean much if misrepresentation or deceptive practices are done and the court finds that, they're probably going to just throw that waiver in the trash and then prosecute you. So it's very strict guidelines for actually if you wanted to try and waive the DTPA. So here's a case example. 1995 has set the standard for as is, and if you're selling it as is, that court case is also in your book. So any known defects must be disclosed. A buyer has a right to inspect the property as is conspicuous, not boilerplate, and both parties are similarly situated. So yeah, that was a court case in 1995, if you want to read on that one as well. Here's a couple more. That one also applied the as-is standard. And in this one, that was in 2011, the buyer could not prove the seller or licensee knew a water well defect. Well, that was actually a pretty recent court case. All right, notice of inspection. So inspection requires a 60-day notice of suit, and the defendant may inspect disputed goods. The defendant may offer to settle, and it's not an admission of guilt. It may limit damages, and it may limit attorney fees. So basically, this is just trying to keep the matter out of court. It's trying to get it resolved before it actually has to go to court. That's basically what that 60-day notice is, and giving them, the defendant, these rights. It's just basically, can we get this solved before we actually have to go before a judge? Can we do that? So that's what this little requirement is. This notice requirement is. Nobody wants to go to court if they can avoid it, right? Some exemptions for prohibition against the waiver. So if a contract is written waiver of rights may be enforceable if the total consideration exceeds $100,000, if legal counsel was involved, or does not involve the residents at all. So these are some exemptions to the prohibition against the waiver to waive the DTPA. If written, as I've been saying over and over, if written, always get it in writing. So if the contract is oral or written, the waiver of rights is enforceable if the consideration exceeds $500,000 or it does not involve the residents as well. So in 2011, revisions meant to insulate licensees in professional service cases if professional service is based on opinion, advice, judgment, or similar professional skills. There's an example in your book as well. So in 2011, they revised it again to exempt certain things. Some more exemptions. Exemptions do not apply if it cannot be characterized as advice, judgment, or opinion. So express misrepresentation of a material fact or a deliberate non-disclosure or an unconscionable act. So the exemptions do not apply if you do any of these. You would still be prosecuted under DTPA. So an unconscionable act, as we were saying, it's a form of deception. There's equitable relief to a person who was tricked or swindled. It means they get their equitable, any damages they receive, they get that back. And there was another case in 1995 where Smiths knowingly and intentionally committed fraud. So I'm guessing Smiths lost that case. So producing cause, here's a couple more. Producing cause is a contributing factor that produces injury or damage. And it's not required to prove deceptive or misleading act. It's also related to a material fact or directly caused injury. And you need only to show that the act was the contributing factor to sue for that. And there's a couple cases from that one as well. 1981 with buyers or consumers, and 1985 Reliance was not the procuring cause, and verbal misrepresentation is admissible or can be admissible. So the DTPA relief for customers, any economic damages, attorney fees, and court costs. Economic damages would be, so if I was in a contract, right, with a buyer, my client was a buyer, and the other client didn't do their duty, and now my client has to rent out a house for a few days or for a few months. He's having to pay rent, right? So he could actually sue for the rent at that point. You could say it was an economic damage that happened to me. I had to pay for this, and if it goes on for 3 more months, well, then that keeps adding to it. And you could actually sue for that, saying I took some economic damages. And any attorney fees, like I said, and court costs. Extra money for mental anguish, if it was knowingly or intentionally committed. So even your mental anguish, you can claim for that. Up to 3 times economic damages for mental anguish if it was committed knowingly or if it was committed intentionally. Like I said, 3 times. Even mental anguish, you can sue for that. I don't know how you would prove that. You really probably wouldn't at that point.
Yeah, I think we talked about this in my course where we were talking about like mental damage versus physical damage, and you can sue for mental damage or mental anguish or whatever, but I remember we talked about that, like, if there's one thing the court's gonna throw out, it's mental anguish. It's because it's very hard to prove. So even if you say, well, like, they owe me this much because I've suffered because now I've been thinking about this and this happened and I think about this all the time and whatever. It's hard to prove that, and so that's the first thing the court will throw out, and then they'll just usually end up just being charged for the physical damage, not so much the mental anguish. Yeah. If it's serious enough and the court, can buy it or whatever, then you can be sued up to 3 times for it. But it's just that's usually a thing where you can go 10,000 for this and 10,000 for this, and they go, all right, well, let's just do 10,000 for the physical and not worry about the mental stuff. Like that's usually what they'll do is throw out the mental if there's nothing to it, like you can't prove anything about it.
So you can, unless you can prove like, hey, I got schizophrenia or something.
Yeah, if there's something serious like that, yes. Yeah, but it's hard to prove that. So
or depression, I guess.
Yeah.
You could probably prove that if you had a doctor, go to the doctor. So yeah, he's probably depressed. But yeah, you can even sue for mental anguish if it was committed knowingly or intentionally. So any defenses, the DTPA limits enforceability of any waiver. And your defense 1 would be liability and damages can be limited if the consumer filed in bad faith. So if that means they were trying to sue me just to bring me to court because they wanted revenge or something because of something that I did. it's in bad faith. There's no real grounds to it. But you could still get sued for that, but your liability and your damages would be limited. If the defendant made reasonable attempt to settle it, so if I tried to pay him, I don't have all the money, but I tried to pay as much as I could, then the court would say, okay, well, he's trying to make it right. We can limit his liability or his damages. Stuff like that. If you actually tried to make it right, or if someone just, they filed in bad faith, I'm going to get back at Steph and drag him to court. He's going to have to pay all this in fees and so on and so on. So that's one defense you could have against DTPA if it were to come in, if the lawsuit were to come into your lap. Defense 2. So if you relied on information received in writing, remember we've always said if it's in writing, then it's correct. So if I had information in writing and I relied on it, I could have my liability and my damages limited. So if the information was received in writing and gave written notice of reliance, so if I have the info in writing and I say, yeah, I acknowledge this form, and that I did not know and could not have known. So basically, yeah. So even in writing can be construed, but it would still limit any damages that you would have to pay because you had it in writing. And there was a court case in 1987, also in your book. Here's a couple more court cases. These were the unsuccessful defenses. Yeah, if you wanted to read about those, also in your book.
Well, so they did the defensive, it just didn't work?
So yes, the defense didn't work. So these were all losing cases for one side, obviously won, but unsuccessful defenses. So if you want to read about those, they're also in your book. So groundless lawsuits, that happens. That happens a lot. Attorney's fees and court costs to the defendant if the lawsuit is groundless. If it's bought in bad faith, if I just want to take this person to court to make him have to pay money and cause a big scene, or if there is any purpose of harassment. I'm just trying to harass this person by taking them to court. That would be another bad faith issue. That would be in revenge. So these would be some groundless lawsuits. One of the primary objectives of the legislator that was created in 2011 was the exemption to insulate licensees from groundless lawsuits. So it helps protect our agents, the agents in the field, from groundless lawsuits such as this, which do happen quite often, actually. Okay, so ethical and legal concerns. So even though we are exempt in some cases, as far as the DTPA is concerned and other lawsuits, just keep in mind you're not protected completely. So you can still lose your license. There's TREC rules, canons, and our code of ethics. I'll tell you now, you don't want to have to go in front of TREC or even the National Association of Realtors. You don't want to have to go in front of them. So just obey the law. At worst, they could send you to jail if you did something real bad, but they could also, you're going to be paying court costs and fees, all that stuff, and you'll also lose your license, which means you won't work in real estate anymore. So even if you break the NAR code of ethics, there could be some actions that they take on you, and any other legal or ethical issues. All right, we're almost done with this chapter. Actually, we pretty much are. We're on key points. Then we're going to do chapter 12. Now there's about 300 slides in chapter 12, so we might be here till about 12 tonight.
We'll try to rush
I have
through
coffee.
I'm just kidding.
it. That's
gonna get in that
next
back room.
That's next.
Yeah,
Yeah,
that's
that's
for
next
me.
class. Yeah,
Yeah.
Oh.
300 slides.
I done got some long ones in my class. So
I think he actually does have one. There was 100 and something slides.
Yeah, I have one that's like 100.
So he's got to break it up differently. No, it's not 300 slides.
140.
Yeah, it's about 200.
We're not that sure.
I overshot it.
Yeah, it's 137.
Okay, so key points. DTPA is to protect consumers. Remember, it's not to protect agents, it's consumers from false and misleading business practices.
You will be asked that on the real estate.
You will
I can guarantee that. You will be asked, what does DTPA protect consumer or agent or whatever? You will be asked that.
agent, let's say agent, broker, something like that.
Yeah, you will be asked that.
Consumers, it's to protect consumers. DTPA consumer may not have to prove intention to deceive. So unless it's a licensee. Licensees you still have to prove, but normal, everyday people, you would not have to prove. Many recover economic damages, attorney's fees, and court costs. And if they did it knowingly, you can get up to 3 times the amount, like we said. The best defense is to encourage use of third-party experts. So if you don't know something, like I said, if you don't know something, say, I don't know. I don't know for sure. It's not bad to admit that you don't know something. If your client sees that you don't say, I don't know, they might, they'll think, well, he doesn't know everything, but you just say that and you can say, but I can find the information for you, or I can try and find it. Then it gives them more confidence in you.
People typically tend to respect you more if you're actually willing to be like,
Admit,
I don't know that. Like that's something I don't know. I can ask and get back to you.
Yeah, exactly. If you can find the info, just let them know.
Yeah.
Just assure them you can get it to them. A specific exemption for real estate brokers and salespersons as far as the DTPA is concerned. Suggestions for brokers: train associates with proper methods of obtaining information and how to relay the information to clients and consumers. And develop a written policy. Document all contracts and sources of information, which we do in this office. All right, we just have a couple questions and we're going to switch over to, we got a little time, so we'll do the questions, at least a few of them. Okay. What is the purpose of DTPA? Giovanni, how's it going, man?
Hey, how's it going? Pretty good.
Good. So what's the purpose of DTPA?
Dang, I don't know. I'm playing. It's to protect the consumer.
Come on.
I got you.
Exactly right. Exactly right. It's to protect consumers. Very good.
Yep.
List some of the activities that would be considered violations of the DTPA. How about you, Wyatt? Just give me 2.
The unconscionable.
Unconscionable, okay.
And then misleading and
Intentionally misleading.
intentionally misleading. I guess it's the same.
Sort of, yeah.
I don't want 2 different answers, I think.
No, I'll take it. I'll take it.
Very
Very good. Compare and impress. Okay, that's a really, really tough one. Compare and contrast the actions of fraud and misrepresentation under common law, statutory fraud, and DTPA. That is a tough one. So the actions for fraud under common law, I guess you could be, I'll just answer this one. I guess for the action of fraud in common law, you could be charged criminally, whereas for the DTPA, it would just be a civil matter. I guess that could be what the difference is between those two, if that makes sense. What constitute unconscionable actions? Why, you know this one.
What constitutes it?
And what constitutes it? What is it?
Oh, to like shock everyone.
Shock the court.
Yeah,
Exactly
gotcha.
right. You got it, man. Okay, two more. A producing cause is a contributing factor that, in the ordinary sequence, produces injury or damage. What is the difference in the burden of proof in common law statutory fraud cases and DTPA cases?
That's another big one for the teacher.
That's a tough one as well.
Yeah.
I think that one goes into the same thing, whereas in fraud, you could possibly go to jail. With DTPA, it would just be a civil matter. I think that's pretty much the same thing, isn't it? Yeah. It's basically the same question, just worded differently. Last one. Discuss specific examples of when a consumer might perceive a licensee's opinion as fact, thus making the conduct actionable against the licensee under the revised DTPA. You want to do this one, Carl?
I'll do it.
Go for it.
So the question said that to distinguish between opinions and fact.
Well, so what is an example of when a consumer would think that what I said was actually fact, not opinion?
We just talked about foundation issue, like
Mm-hmm.
this house has a foundation issue. That's a fact.
That's a fact, exactly. So if I were to say something that could be perceived as a fact, not an opinion, it could be actionable under the DTPA. Very good. All right. One more chapter and we will be done. And after the chapter, we'll go over when we're going to do our test next week and so on. Go ahead and stop the recording.